I put all these cases together in an affidavit, an informal motion to Judge Seabright, the head federal judge in Hawaii, and asked for my documents to be given to the sitting grand jury. They have grand juries sitting all the time in case they're needed. So I did this. This was back in December 2015. I immediately got a letter from Seabright's head clerk that stated they weren't accepting it, and that if I didn't come and get the documents, they were going to destroy them. They're going to destroy court documents. That's a violation in itself. So I called up this court clerk. Her name is Leon Abernathy, also a prior member, prior employee of the Justice Department. I had a long conversation, recorded of course. Why? What law gives you the right to destroy my documents and to decline giving them to a grand jury? Her answer was, it's a general opinion around here. And my comeback question was, well, whose opinion? Is it the judge's opinion? Or is it a group of judges? Or is it you? Or is it your colleagues in the judge's office? Who is it? And she said, it's just a general opinion. So I said, thank you. Then I sent a long email to Judge Seabright himself. And believe it or not, if you look hard enough, you can get those emails. And I explained to him why I believe this case needed to go to a grand jury. And I reminded him of the Fifth Amendment to the Constitution, as well as Rule 6 of the Federal Rules of Procedure, Court Judicial Procedure. I didn't get an answer back from the judge himself. I can imagine why. But I did get a phone call from the same lady who threatened to destroy my documents. And this phone call said that they were, in fact, going to present my documents to the grand jury on the following Thursday. This would have been in January, about January 8th or so. Okay, great. So 3, 4, 5 months go by. Nothing. No investigation as far as I'm concerned. As an investigator, I know the very first thing you do when you get a case like this is you call the person who made the complaint and verify all the information that he gave and try to get more information if you can. Nada. Nothing. So I had a friend, journalist of mine, make a call to the court and inquire about it. And he recorded it also. And he also talked to Miss Abernathy, who was the head clerk. And in the recording, she says, yes, the information is given to the court, and we don't know what's happening because we don't have any contact with the grand jury. I mean, the information was given to the grand jury, and we don't have any contact with them. It's against the law, yada, yada, yada. So, okay. Another sign that the things are rolling along. And then I got contacted by another victim, Mrs. Duran, whose husband died, and Paul Sulla was involved in that one, and all of a sudden the husband's property is being taken by Paul Sulla, including the house they live in. So I make a phone call to Miss Abernathy in Judge Seabright's court, and I said, look, I got another victim here. Who is it that's doing the investigation? I can either send it to you directly, or I can get in contact with the person personally and make this information available to them. And she said, well, you're going to have to contact the U.S. Attorney. That's who's involved in this. I said, okay. Called up the U.S. Attorney, ran the situation by them, and they, we don't know nothing about this. Well, you better call the FBI because the investigation isn't being done by this office. So I called the FBI, same response. Don't know nothing. Except the agent that I talked to said, well, what's the docket number on this? Or what's the case number? And I said, I don't know. I never got received. Won't get us the case number. Maybe we can find it because as far as we know, there's nothing going on with that. So months went by, back and forth with Abernathy, but via email. And finally, in one email, I was saying to her, look, I've got this victim here. You must, the law says you have to sign a case number to all the documents coming into the court. What's the docket number on this? so I can get the information to the FBI or to whoever's doing it. And she said in her email, we didn't give the information to the grand jury, and we didn't give it a docket number. But I did make a phone call to the U.S. Attorney's Office and explain to them about the case. But I don't remember who I talked to. This is what she told me. Of course, I have a copy of that. So here I have a federal judge squashing a grand jury investigation. That's exactly what's going on. So that's a big deal. The problem is you can't bring charges against a federal judge for actions they commit in court. That's not really the case here. This didn't go to court, and it wasn't a decision that he made. He made it on his own. And any decisions that judges make on their own, they're not protected by the umbrella of no prosecution. So that's basically what this request for intervention is made to the Ninth Circuit. That's basically what this is all about. But prior to filing this motion for intervention to the Ninth Circuit, I had made an actual formal complaint to the same court, the Ninth Circuit, on Judge Seabright for failing to do his duty, failing to transfer these documents to the grand jury as I had requested. And I got a letter back from someone in the court signed by the judge that my allegations were unfounded. Now, so I appealed it because I can't believe that any judge that looks at the evidence that I had here on Seabright would say it was unfounded. First of all, they claimed I couldn't make a complaint on Abernathy because I wasn't going through the right process to complain against a court employee. I reminded them in my appeal that I wasn't complaining against Abernathy. I was complaining against the judge who was responsible for Abernathy's actions. And then I included all the evidence that I had I have been talking to you about with my appeal, and I haven't heard back from them, whether it was accepted or what. But when you make an appeal on a complaint to a judge, then it goes to a panel of judges who look over what you have and make a decision on whether you have grounds or not to actually request an investigation into Seabright's actions. But even if they do accept it and they do find Seabright guilty of something, of one of the charges that I'm asking, they really can't do anything to a federal judge. That can only be done by Congress. Congress appoints the judges, and they're the ones that can impeach them. But they have administrative things, penalties that they can level against Judge Seabright, but really not much. Seabright is basically dealing with impunity here, except for private felony charges, which is what I'm trying to do with this asking for intervention by the Ninth Circuit. Judge Seabright, Abernathy, and whoever else was involved in disposing of my documents have all committed crimes. All of them, including Seabright. He's the one held responsible for the actions, and he knows about them. But he made a mistake. When he answered to my original allegations of impropriety in the courts to the Ninth Circuit, he said that he couldn't give the documents to the grand jury without having it first investigated by the Justice Department, which is not true. And here's why. We have the Fifth Amendment to the Constitution, which deals with a person's right to get involved with a grand jury as a citizen. But we have other things that support that Fifth Amendment. And one of them is the Federal Rules of Criminal Procedure put together by the U.S. Supreme Court. And what it says is, in general, when the public interest so requires, the court must order that one or more grand juries be summoned. A grand jury must have 16 to 23 members, blah, blah, blah. So the court rules themselves say give the court the authority to convene a grand jury. It doesn't say anything about the Justice Department. So let's see how the court has applied these rules and regulations and the Fifth Amendment to actual cases. And this is a very important one, and it's going to take a few minutes because they really elaborated a lot on the use of grand juries in our country. Even though this case isn't exactly the same situation that I'm talking about, what they say about the grand jury is, and here's the first paragraph. It says, whereas the grand jury is an institution separate from the courts, over whose functioning the courts do not preside. Any power federal courts may have to fashion on their own initiative rules of grand jury procedure is very limited, and certainly would not permit the reshaping of the grand jury institution that would be the consequences of the proposed rule here, referring to the case that they're dealing with. Moreover, motions to quash indictments based on the sufficiency of the evidence relied upon by the grand jury have never been allowed, and it would make little sense to abstain from reviewing the evidentiary support for the grand jury's judgment while scrutinizing the sufficiency of the prosecutor's presentation. So what they're saying here is that the court doesn't have anything to do with deciding who gets to have a grand jury or who doesn't, or what documents are proposed to the grand jury or what isn't. They're saying the grand jury functions on its own. And you'll notice not one time do they mention the involvement of the Justice Department. When you have a federal judge making decisions such as Judge Seabright did as to who investigates allegations of wrongdoing and who doesn't, when the litigant is specifically saying, we want a grand jury involved in this because we're alleging corruption within the Department of Justice, and then you have a judge saying, well, we're going to give it back to the Department of Justice. Number one, that's not within the power of the judge to do that. Number two, if you have any kind of joint agreement or collusion between the Justice Department and the federal courts, you have a violation of separation of powers in this country, and that violates the separation of power doctrine. So Judge Seabright is digging himself a hole, it would appear, but that's not all. Let's go on with this particular Williams case. The Supreme Court goes on with their description of the powers of the courts versus the grand jury. And this paragraph says, quote, the grand jury's functional independence from the judicial branch is evident both in the scope of its power to investigate criminal wrongdoing and in the manner in which that power is exercised. Unlike the court, whose jurisdiction is predicated upon a specific case or controversy, the grand jury can investigate merely on suspicion that the law is being violated, or even because it wants to assurance that it's not being violated. And then they support that opinion by the United States versus R Enterprises, Inc. It's case 498 in the U.S. 292297. Now here again, the Supreme Court is telling us that the grand jury is an investigative entity in itself. And so where Judge Seabright gets the information that he needs another entity to investigate allegations of criminal wrongdoing is beyond me. The Justice Department, when they're involved in a grand jury case, is one of support and one of assistance. And so if they do any investigating for the grand jury, it's at the behest of the grand jury. The grand jury will request, we want some help investigating this, and it's their option to do that, and then the Justice Department is obligated to do so. But for a federal judge to say, wait a minute, this doesn't go to the grand jury until after the investigation by the Justice Department, who happens to be listed as a defendant in the case, is unconscionable, and why this is unfounded in a complaint is beyond my imagination, actually. And to make matters worse for Judge Seabright, the Supreme Court goes on to say, the grand jury requires no authorization from its constituting court to initiate investigation. Okay, that's pretty plain. They're saying, we don't care what the court says. The Supreme Court goes on to say, the grand jury requires no authorization from its constituting court to initiate an investigation. Nor does the prosecutor require leave of court to seek a grand jury indictment. And in its day-to-day functioning, the grand jury generally operates without the interference of a presiding judge. You can't get any more plain than that. And here we have a classic case of the judge interfering in what the grand jury is going to investigate or not. And not only do they operate without the interference of a presiding judge, it swears in its own witnesses, the grand jury does, and deliberates in total secrecy, the grand jury does. And they continue, we have insisted that the grand jury remain free to pursue its investigations unhindered by external influence or supervision, so long as it does not trench upon the legitimate rights of any witness called before it. And that's backed up by United States versus Dionisio. Recognizing this tradition of independence, we have said that the Fifth Amendment's Constitution guarantee presupposes an investigative body acting independently of either prosecution attorney or judge. And here we have the head federal judge of the District of Hawaii telling the Ninth Circuit that he can't give my information to the grand jury because it requires investigation by the Justice Department first. And so my predicament, actually in November of 2017, not too long ago, was this. Okay, so I've gone through the process. I've tried to get an investigation into a capital murder case by first the Kauai Police Department, and then the Hawaii Attorney General's Office, and then the FBI and the Department of Justice, and all of them turned a blind eye and a blind ear to my allegations. And remember, they don't have to be substantiated by evidence. Only the grand jury can investigate what they want to. However, in my case, I do have evidence, lots of it. So now I'm at the federal court level, and I have a judge saying, I can't do nothing with it. First they threatened to destroy the documents, and now they're saying they can't, they recognize the fact that the evidence is there, they just can't give it to the grand jury. So what do? My first inclination was to, okay, I'm going to ask for a change of venue. I'll go to the Judge Thomas of the Circuit Court and ask for a change of venue, and then see if I can get a grand jury in another district, one that's not so corrupt. But I'm not so sure that was the correct move to make. I even had an affidavit for a second grand jury prepared and ready to go, and I woke up in the middle of the night one night and said, no, what I'm going to ask is for the Ninth Circuit to get involved in this themselves. If they want to change the venue, they can do it on their own, but I don't need to tell them this is what's needed. So what I'm asking the Ninth Circuit in this motion to intervene. The goal is to get a grand jury to go back in, unzip the folder that holds this old murder case, and start from scratch and bring some justice into the picture. So that's what this motion does. But as backup evidence listed on the evidence page, I have listed the old affidavit file as evidence that submitted this, and I have a new proposed grand jury file for the new circuit court judge to look at. And in this motion, I am suggesting to the judge that we do need 2 grand juries. We need one to pick up where the first one left off and go into the murder case, but we also need a second one. We need what's called a special grand jury to look into allegations of corruption and separation of power allegations between the Seabright courts and the Hawaii Department of Justice, the Hawaii AG's office, and also into the U.S. Attorney's Office. And by the way, during this period of time, there was no permanent U.S. Attorney. The one that was in there when I began was appointed by the Obama administration, and Trump asked for the resignation. So they've been operating with a ad hoc U.S. Attorney until one's appointed, and I don't think one's been appointed yet. So that's what this is all about. If you want to get into the meat of the thing and read everything that I've done, it's all available out there for the public now. And this is a very important motion, and I'm sure that there are some bona fide constitutional attorneys looking at this, because Judge Thomas, the head Ninth Circuit Court judge, is bound to make a decision. He can do the same thing Seabright did and just ignore it because I didn't have a docket number. A docket number was never assigned to the case. So that's Judge Seabright doing. Or he can deal with it. If he's a smart man, I think he's going to have to deal with it, because if he doesn't, he's in the mix with Seabright. He knows what the law is. Some of the laws are made by the Supreme Court, some of them made by the Constitution. You can't just leave me flopping in the air again, because there's other areas I can go to if this doesn't work. So God bless you all. Take a look at what I've presented here. It's done in honesty. I haven't made one dime in this. I have written a book called The Fifth Seal. It's right here. It was completed this year, but it obviously wasn't. I wrote it prematurely because I didn't have this motion in there. But one of the last thing I want to say is that it goes back to the murder of a 4-year-old girl. We have a person that has come forth and admitted his participation in that crime, and the family has supported me all through this whole thing. Timmy Woolsey and his wife have been backing me up in this. I have received no funds from anybody to take this task on, and it has been significant to my pocketbook to do this. The book, it hasn't caught on yet, so I haven't made too much money off of that. And all of this is covered in videos. If anything happens to me, I would like this video to be a testament to what I was trying to do, and hopefully can be used to go after anyone that might have had something to do with my demise. So God bless you all. Thank you.